Hello class, welcome back to Business Law. This is your Professor Daniel Crane, and today we're talking about employment law. The Title VII of the Civil Rights Act of 1964 prohibits discrimination that is based on race. Congress also included sex, religion, national origin, and color as prohibited bases for hiring, promotion, layoff, and discharge decisions. Interestingly, out of that, you might have noticed that age is not included. So we see we've got race, sex, religion, national origin, and color. This applies to employers with 15 more employees whose business affects interstate commerce, all employment agencies, labor unions with 15 or more members, state and local governments and their agencies, and most federal government employment. So that's the types of businesses that Title VII applies to. And the remedy here is back pay, hiring, reinstatement, and promotion. What was the Civil Rights Act enacted to prevent? It was enacted to prevent employers from exercising their power to refuse hiring of those protected classes. So we see here those protected groups for Title VII again would be race, sex, religion, national origin, and color. And we're looking at it's protected when you're looking at hiring, promotion, layoff, and discharge decisions, those four types of business decisions. The Equal Employment Opportunity Commission, the EEOC, Title VII established this, so that would be the statute that enacted or that was created in order for the EEOC to be an administrative agency, hearkening back to that chapter. A victim of discrimination who wishes to file a suit, this is very important, must file a complaint with the EEOC to permit the agency to attempt conciliation of the dispute. So before you can file in your federal court, your federal trial court, that type of arena, first you must file a complaint with the EEOC. Two major types of Title VII cases to consider. Title VII created these two thought processes for determining when this type of discriminatory practice is occurring. The one type of case would be called cases of disparate treatment. This would be a form of employment discrimination that results when an employer intentionally discriminates against employees who are members of a protected class. So disparate treatment, that is intentional discrimination, because of, again, those protected classes we were talking about, race, sex, religion, or national origin. When people in that class have been treated less favorably than others within the organization, that's when you can bring suit. To prevail in a disparate treatment suit, the plaintiff must show that the company intended to discriminate because of one of the factors that the law forbids to be considered. Continuing with cases of disparate impact, a form of employment discrimination resulting from employer practices that appear to be neutral but that have a discriminatory impact on protected classes. The employee need not show that the employer intended to discriminate, but only the effect or the impact of the employer's action was discriminatory. The plaintiff must demonstrate the reason for the employer's conduct, such as refusal to promote, was not job-related. Disparate impact cases often arise out of practices that appear to be neutral or non-discriminatory on the surface, such as educational requirements and tests administered to help the employer choose the most qualified candidate. An employer is not free to use any test it pleases. The test must have a genuine relationship to the job performance. So again, the two types of cases, one would be intentional discrimination, that's what we're talking about above. There, the plaintiff must show that they intended to discriminate. So this is intentional discrimination. The plaintiff must show that the business intended to discriminate. And then we have this less intentional discrimination was the cases of the disparate impact, and there the employee need not show that they intended to discriminate, but only the effect or impact of the employer's action has a discriminatory result. But remember that the employer can't use any test that it pleases, right? But it can use tests that bear a genuine relationship to job performance. Under Title VII of the Civil Rights Act, employment discrimination can be based upon all of the following except. So you might be looking through these thinking, boy, all these things seem like discriminatory treatment under the Civil Rights Act. And remember that a person's age, including minors and people of retirement age, are not a protected class under the Civil Rights Act. Dad applied for a job with Wexler Company. Although she was highly qualified for the job was given to a less qualified Caucasian woman. Dad believes she did not get the job because of her race, color, and national origin. Dad may have a claim for age discrimination. Nope. Intentional discrimination, disparate treatment. Maybe. Unintentional discrimination, disparate impact. Potentially. Quid pro quo. I would believe the answer here would be intentional discrimination. It seems like she was intentionally chosen because of her race, color, or national origin, and the other person was chosen who was less qualified because of their race and national origin, being the Caucasian female. Therefore, you would have intentional discrimination here. The person intended to discriminate. It doesn't seem like they have some neutral process in place here that would make me think that it's unintentional disparate impact treatment. If an employer has a hiring practice that appears to treat everyone equally, but it actually qualifies a disproportionate number of qualified people from a protected class, this could be a basis for a claim of unintentional discrimination, disparate impact. So disparate impact, remember, that's the unintentional, and the disparate treatment, that is the intentional discrimination. Discrimination based on religion, that would be an issue underneath Title VII. It's protectable class. You must reasonably accommodate to an employee's or prospective employee's religious observance or practice unless the employer can demonstrate that a reasonable accommodation would work an undue hardship on the conduct of the employer's business. The company need not make an accommodation that would impose more than a minimal cost. Under Title VII of the Civil Rights Act, all the following statements are true except. So we see here the very first option sounds like it's the one we want to choose here. An employer must accommodate every religious practice. That would be false. We just learned up here the employer must reasonably accommodate unless it would be an undue hardship on the conduct of the employer's business. An employee who wants to bring a claim against an employer for discrimination, we're reading through here. Remember, we talked before about the EEOC, the administrative agency that was created, and first the employee needs to file a complaint with the EEOC before they can bring their complaint in court. Sex discrimination, or refusal to hire or promote a woman simply because she's female, is a clear violation of Title VII. Again, we have a protective class. Under the Pregnancy Act of 1978, Congress declared that discrimination because of pregnancy is a form of sex discrimination. Equal pay for equal comparable work has also been an issue in sex or gender discrimination. Plaintiff has the initial burden of proving discriminatory intent, and then burden shifts to the defendant to show a plausible non-discriminatory reason for its hiring decision. Why is that important? Remember, when you're a plaintiff coming to court, you're going to have some type of burden of proof to bear. Sometimes you might have a lesser burden of proof, a greater burden of proof, some type of medium burden of proof. Here we're seeing the plaintiff has the initial burden of proving discriminatory intent, and after they hit that bar, the burden then shifts to the defendant to show a plausible non-discriminatory reason for its hiring decision. So the plaintiff's initial burden here, in my point of view, would be a lower standard in regards to the amount of evidence needed to bring to shift that burden over to the defendant. Sexual harassment, there are two major categories of sexual harassment: quid pro quo and a hostile work environment. Quid pro quo comes from the Latin phrase one thing in return for another. If any part of a job is made conditional on sexual activity, then that is a quid pro quo sexual harassment. We're going to jump back up to that question in a second here. Hostile work environment, sexual harassment. Here, an employee has a valid claim of sexual harassment if sexual talk, imagery, or behavior becomes so pervasive that it interferes with the employee's ability to work to her best capacity. On occasion, courts have found that offensive jokes, if sufficiently frequent and pervasive in the workplace, can create a hostile work environment. Likewise, comments about body parts or public displays of pornographic pictures can also create a hostile work environment. In short, the plaintiff can be detrimentally offended and hindered in the workplace, even if there are no measurable psychological injuries. According to your textbook, if a plaintiff wins a discrimination claim under Title VII of the Civil Rights Act, the court can award. This is from a much earlier slide up above, and the answer here is going to be hiring, reinstatement, promotion, and back pay. That would be the first one. So under Title VII, the type of remedies that a plaintiff can receive from the court would be hiring, reinstatement, promotion, and back pay. Discrimination based on race, color, and national origin. Title VII was primarily enacted to prohibit those protected classes. Color refers to the color of a person's skin. National origin refers to their ancestry. Which of the following correctly identifies the protected classes of people under Title VII? Remember, Title VII does not include age. Does not include age. So you want to watch out for that one. In addition, it doesn't include disability. It does include, I'm looking at the third answer there, race, color, national origin, sex, and religion. And that would be your correct answer. The other ones there are trying to slide in on you age and disability, which are not protected under Title VII. So Title VII, there are some defenses, some exceptions, some means that a business can act in an ordinary course of business in a reasonable way in order to not violate any Title VII protected classes. So we have merit here. Employers are allowed to select on merit and promote on merit without offending Title VII requirements. Merit decisions are usually based on work, educational experience, and ability tests. All requirements must be job related. For example, the ability to lift a heavy carton of 60 pounds or more is appropriate for certain warehouse jobs, but is not appropriate for all office workers. Seniority. Employers may also maintain seniority systems that reward workers who have been with the company for a long time. Higher wages, benefits, and choice of working hours, vacation hours, those types of things are fine using a seniority method. Bona fide occupational qualification, a BFOQ. Under the terms of Title VII, you can have bona fide good faith occupational qualification of decisions in regards to protected classes, but sometimes you cannot. You cannot have a bona fide occupational qualification of race or color. There is no good faith decision that would allow you to get a bona fide occupational qualification for race or color. In the area of religion, as noted earlier, a group of certain religious faith that is searching for a new spiritual leader can limit its search to those of the same religion. That makes sense, right? Bona fide occupational qualification, if you're looking for a new father for your Catholic church, it makes sense that you would want that new father to be Catholic instead of another religion. So, therefore, that would be a bona fide occupational qualification. With regard to sex gender, allowing a woman to be a locker room attendant only in a woman's gym, would be a valid BFOQ. So it's a women's locker room, and then wanting only women's attendants to work in the women's locker room, that makes sense. Bona fide occupational qualification. One important test the courts employ in evaluating employers' BFOQ claims is you're wondering, is this the essence of the business test? So here we go, essence of the business test. This is the finding that discrimination based on sex is valid only when the essence of the business operation will be undermined by not hiring members of a sex exclusively. So we've got some examples here. There was airlines who would only have female flight attendants or female stewardesses to provide a pleasant atmosphere. This was determined not to be essence of the business. Their ability to perform non-mechanical functions or more effective manner than most men may be important, but that's not tangential to the essence of the business involved. Therefore, you could not discriminate. The protected gender here would be men, because they were only hiring women for the stewardess's position. In the 1990s, Hooters had some difficulty convincing the EEOC and certain male plaintiffs that only women could be hired as waitstaff in restaurants. With regard to national origin, directors of movies and theatrical productions under Title VII, they could restrict their roles. Let's say you had an Asian, or you needed your part the actor or actress was playing was an Asian character, then you're allowed to restrict it to only Asians as the type of actor you're hiring. Now, this wouldn't stop them from hiring another race or ancestry to play it, and then dress them up in makeup or something like that. That would be allowed, but they can restrict it to the character the actor is playing. Under Title VII of the Civil Rights Act, employment discrimination applies to discrimination in what types of employment decisions? And here the correct answer would be any employment decision. defenses in sexual harassment cases. So there are some defenses in sexual harassment cases. Employers that exercise reasonable care to prevent and correct any sexual harassment behaviors, and if the plaintiff employee unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer or to otherwise provide or avoid harm, those are some affirmative defenses. The employer, when you have an affirmative defense, that means that the person setting forth that affirmative defense has the burden. So here the business would have the burden to prove one of these valid defenses. Some examples given in the book: employer had a policy that was made known to employees. Moreover, a complaint system had been established and it was not used by the female employee. So if there is a complaint system and then the employee doesn't at first attempt to utilize that complaint system, but instead goes ahead and starts their action with the EEOC, you'd have to start the action with the EEOC by filing a complaint. The defendant business there is going to have the affirmative defense of saying we had corrective opportunities the employee could have used, and then they failed to do so. Affirmative action. Employers may voluntarily use an affirmative action plan to remedy the effects of past practices or to achieve diversity within the workforce. A woman was promoted within to the position of dispatcher, even though a male candidate had a slightly higher score on a test that was designed to measure aptitude for the job. That was considered okay under affirmative action, especially in the area of promotions. Affirmative action is more likely to be upheld. Age discrimination. The Age Discrimination Act protects, so this is different than Title VII here. This is the Age Discrimination in Employment Act. It protects workers over 40 years of age and prohibits forced retirement. The Age Discrimination Employment Act protects workers over 40 from discrimination. It also bans mandatory retirement, and it protects minors from discrimination. Discrimination against the handicapped, this would be the Americans with Disabilities Act. Again, so this is not the Title VII Act we were talking about earlier. This is a separate act to protect handicapped Americans with Disabilities Act, the ADA. This definition includes people with mental illness, epilepsy, visual impairment, dyslexia, and AIDS. It also covers anyone who has recovered from alcoholism or drug addiction. It specifically does not cover people with sexual disorders, pyromania, kleptomania, exhibitionism, or compulsive gambling. Employers cannot disqualify an employee because of the disability as long as they can perform the essential functions of the job with reasonable accommodation. Some examples of reasonable accommodation might include a ramp for a wheelchair. Reasonable accommodation means that there is no undue hardship for the employer, which could be a significant difficulty or expense. The ADA, job interviewers cannot ask questions about applicants' disabilities when making a job offer, but they can ask if a person can perform the work. Requirement for medical exam or a violation of the ADA unless it's job related. Employers may use drug testing, though. However, disability under the ADA will be measured according to how a person functions with corrective devices. So, for instance, diabetes can be corrected with, depending on the type of diabetes, you can have medicine that then solves the diabetes issues. Therefore, because it can be corrected, the individual is not considered disabled because you've got to include the corrective measurement to determine how the person functions with the corrective drugs or devices. The purpose of the ADA is to protect, reading through here, a disabled person who is qualified for the job and who can be reasonably accommodated by the employer. The Americans with Disabilities Act covers all of the following except, remember, pyromania, kleptomania, exhibitionism, or compulsive gambling, specifically not covered under the ADA. Reasonable accommodations include installing ramps, that types of things. Reasonable accommodations that do not pose an undue burden on the employer under the circumstances of each case. That would be a case-by-case basis. Yeah, the second one is not correct because it says only. The third one also says only. It's going to be that that fourth one there, reasonable accommodations that do not pose an undue burden on the employer. Equal Pay Act. Equal Pay Act protects men and women from pay discrimination based on sex. You're looking at equal skill and effort here, and you'll compare jobs of equal responsibility, equal supervision and accountability, or similar working conditions. Just naming the position different from another position doesn't necessarily mean that those positions aren't going to need or be looked at in regards to disparity in pay for jobs that require equal skill and equal effort. In making their determination, courts will look at the stated requirements of a job as well as actual requirements of the job. There are some defenses in having different wages. Remember, seniority, merit, quality, quantity of product, and any other factor other than sex. The employer, of course, will bear the burden of proof for any defenses. Fair Labor Standards Act establishes the minimum wage for a regular work week and for overtime. Prohibits most forms of child labor, establishes a minimum wage for a regular work week only, establishes a higher wage scale for overtime only. Which of the following is true regarding discrimination based on sexual orientation? You may have noticed we've not discussed discrimination based on sexual orientation previously. It's because it's not covered in any of the above acts we were talking about there, and that's going to leave that to states. Some states have laws prohibiting discrimination based on sexual orientation. Employment at will. Employment at will is common law. Remember that employment at will is a common law type of law. We've been talking about a lot of federal statutes, mentioned some state law there. Employment at will is common law, judge-made law. And here the employee can be fired anytime for any reason or even no reason at all. However, there have been some federal statutes and some other inroads have been made in regards to this at-will type of doctrine. There is a tort of wrongful discharge. The wrongful discharge means firing a worker for a bad reason. This includes discharging them for refusing to violate a law, discharging an employee for exercising a legal right, discharging an employee for performing a legal duty, and discharging an employee in a way that violates public policy. Discharging an employee for refusing to violate a law, an example here would be a testifying nurse who saw maybe a doctor make a bad decision during a medical procedure, and then the employer, the business employer, doesn't want the nurse to testify, but she's being called up a witness and has to answer under oath, and then does answer truthfully under oath. Of course, having her lie under oath or willfully violate a court order would be violating a law. Therefore, she can't be discharged for that, even if she is an at-will employee. Discharging an employee for exercising a legal, well, not that she can't be discharged, but it would be a wrongful discharge, giving her some remedies. Discharging an employee for exercising a legal right, such as filing a workers' compensation claim. That's a good example there. At-will employee filing a workers' compensation claim. It would be wrongful discharge to fire them for doing that. Discharging an employee for performing a legal duty, such as jury duty. Discharging an employee in a way that violates public policy. An example in the book there was an at-will employee who was hanging out with some other employees and refused to do the act of mooning during the song Moon River, and she was later let go. Of course, you're going to have to bring an action and prove your claim in order to prove the tort of wrongful discharge, but it does give the at-will employee some remedies. Which of the following is a term or concept where the employee may be fired for no reason at all? That's employment at will. Employment at will exists under common law. That's correct, under common law. Of course, this can be modified by tort law because it's a tort, contract law, and employment statutes, federal and or state statutes can modify employee at will. Wrongful discharge of employee at will does not include a discharge for failing to meet job requirements such as arriving on time every day. That does not include a wrongful discharge, of course. Employment at will doctrine is set forth in where? Where do we get this employment at will doctrine? Remember, it's not a statute like many of these other acts we've been talking about. It is common law. Contract modification from employment at will. Certainly, you can contract around employment at will. You can create an employment contract with different protections for the business owner and the employee. And there are a few states that have created some protections for the at-will employee, creating a necessity for good faith and fair dealing. We have Massachusetts and California doing that, so it's quite in the minority there. The Federal Plant Closing Act also called the Warren Act. That we had an issue in the United States where these plants were closing down and letting hundreds of people go when the plant was moving or shutting down, and giving the employees not even 2 weeks notice, which was creating a large burden on individuals who were wrongfully given the surprise notice. So what Warren tries to do is you need to have 60 days notice whenever you're letting go 50 employees, long-term layoff, reduction, or a shutdown require a long-term layoff of 500 or more employees, or at least a third of the workforce. You need to give them 60 days notice. An employer who violates this act can be suffering for back pay that they should have received during the notice period, as well as other fines and penalties. An employer, though, can get exempted from this. Sometimes there's going to be a business circumstance where they just couldn't reasonably foresee that their plant would have to close, or the employer could have been trying their best in order to avoid the plant closure by seeking capital or doing that kind of thing. Maybe the employer itself didn't want to close down. It was almost a shock to them at that they were going to have to close down, and they weren't successful in keeping it open. So their good faith there can get them exempted out of that. Employee Polygraph Protection Act, no polygraphs, essentially is what that act says. Occupational Safety and Health Act, this ensures general duty to keep employees free from hazards. There's more in regards to that in your textbook, both of those. Employee Retirement Income Security Act, or ERISA, is the acronym for the Employee Retirement Income Security Act, ERISA. It creates some protections in there for employee pension funds, and this was because in the 1960s these pensions were getting to be quite large, and then employees were getting defrauded out of their pensions, their lifetime savings, because it wouldn't vest even though they were about to retire, or it wasn't properly protected and people are absconding with it, that type of thing. So it's created some protections in regards to vesting with the employee inside of 5 years, some type of insurance and disclosures and that type of things. But there's more of that in your textbook. Fair Labor Standards Act. This act prohibits most forms of child labor and establishes a scale of minimum wages for regular work week and a higher scale of overtime. Under the FLSA, a successful employee will receive double the amount of back wages due. Workers' compensations law. This is going to be a state law here, and it creates a pool that's funded by employers so that employees will be protected based off of work-related injuries, hospital bills, and that type of compensation. It protects the employee and the employer in its state law. Three important attributes there. Workers' compensation laws are, remember I said state law, it's not state and federal. So when you're looking over for trick answers in regards to workers' compensation not federal, so you're looking for state. So that narrows us right down to our second answer here. State laws that compensate employees for work-related injuries or illnesses suffered on the job and pay for hospital and medical expenses. Other state laws. So we went through a volume of federal statutes. We talked a little bit about common law in regards to the wrongful discharge, and then we talked about workers' compensation being state. Now, states can enact their own types of protected classes and anything that we talked about in regards to federal. And a lot of times states do. And when can states do that? Although it appears most employment law is federal, it's largely actually governed by state law because Congress has allowed it, declared it. Federal courts defer to state agencies to enforce anti-discrimination provisions as long as they parallel the statutes, the federal statutes, with remedies similar to those of the federal law. Basically, you're looking for the states can go beyond. They can create even more powerful enforcement and protections for the employees. They can't erode away on the federal protections created, but where they're layering in some additional protections, or at least mirroring and providing that minimum ground floor of the federal protections, then the states can go ahead and enact their own things, and they can create new protected classes, such as sexual orientation as a protected class. We have overweight as a protected class also from some states. Remember, I don't know how many, let me see how many states this is. Two states on the overweight. That's interesting. The Civil Rights Act provides as follows. Federal civil rights laws that take precedence over state civil rights laws. Nope. Federal courts must defer to state agency law if the state agency law goes further than the federal law in banning certain forms of discrimination. That would be true. Federal courts must defer to state agencies only if the state agency laws are the same or similar to the federal agency law. That's not correct. It doesn't have to be the same or similar. It can go farther than state agency law may not go further than federal agency law in banning certain forms of discrimination. And that's false. They can. So federal courts must defer if the state agency law goes further than the federal law banning certain forms of discrimination. It doesn't have to be the same. All right, thank you very much for listening in, and I hope everyone has a great week here and that you've learned something valuable about employment law. Have a great day. Professor Crane signing out.